Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal educational content, and today may be the day I earn your subscription. So for today, we are doing day 11 and the last regular day of the Kyle Rittenhouse trial, because the only thing left is for a verdict and a judgment. And we don't know when that will come. It could come tomorrow, or it could come at some other time. But the jury will get the case first thing in the morning. The arguments are done. The case is submitted and closed. There's nothing left to do but for the jury to decide Kyle Rittenhouse's fate. How fun and exciting. So we're going to go over the last day of the trial and try to give an assessment. So we start with the prosecution, who, because they have the burden of proof, gets to go first, and they also get the last word, which may seem a little unfair, but that's the way it is, right? So whoever has the burden of proof gets to go first and gets to go last, which of course in the case of the government is, or in the case of a criminal case, is always the government. So that's how that works, and that's what we saw today. So we start with Binger, our favorite effeminate, snappy, suit-wearing prosecutor. And he started off very strong. Reminded me of his opening arguments on day 1 or 2, or however we're counting this at this point. But it reminded me of his opening arguments. It was very good storytelling, very well organized. It was, reminiscent of exactly what I saw during opening. It was, again, not to say that this is always a problem when I analyze these things, because people get mad at me when I say nice things about the prosecution or their argumentation style, but I just try to give you an honest assessment, for better or worse, and whatever happens, I guess. But what I saw was in the first half, and after the break is a whole different story, but in the first half I saw exceptional public speaking. I saw pretty much all the hallmarks of like Toastmasters, which I've done for years in terms of public speaking: thematic elements, storyboarding, signposting, just creating the narrative, really good articulation, really good narrative drive, basically all the things that you would want from a persuasive speech. It was, in the first half, a wonderful persuasive speech, to be sure. And volume is waffling. I don't know anything about that. I mean, it's just the same thing it always is. Anyways, so the volume was apologize, not the volume is waffling. So it was just a very good performance all throughout. Just really, really liked it. Now, of course, as I tried to make clear on Nick Rekieta's stream, there are some, of course, ethical issues here that are notable. The prosecution has ethical duties, not only to try to win, but also to seek justice and not bring shit complaints. So, if we put aside the ethics concerns and the morality concerns, then what he said, then from a public speaking perspective, it was really, really good. And I don't know if someone was attempting to Godwin my argument or not, but someone on Twitter said that's a little bit like saying that Hitler was a good public speaker. To which I would say, actually, yeah, in that case, it's kind of similar, although Hitler was a much better public speaker. That isn't, of course, to say that he's moral or what he's saying is good or positive in any sort of humanitarian sense. It's not. Hitler's an obviously evil person. This should not be controversial. But for him being evil and for him being reprehensible, to say that he's not a good public speaker, it's like, well, he's pretty damn good. There's kind of part of a reason that he was able to convince a lot of Germans to follow him. That public speaking helped a lot. So to be able to recognize that skill set, I think is really important. So, if you're not looking at that and don't separate those things, I think you run into problems. You need to recognize when people have skills and when they don't. It doesn't require them to be evil or good, moral or immoral, or amoral, any of those things. It's just like, hey, he's a really good public speaker. He knows how to put together a persuasive speech. I find his speech very persuasive. That isn't to say that I agree with it, because I don't, because I know he's talking shit. But I also recognize, like, the scoring sheet in my head from public speaking. I'm like, as persuasive speech goes, this is going pretty damn good. And it would be, I think, remiss of me as an evaluator not to give you my honest opinion in terms of what I think it is. It's like, and as I said in the first half, if you're looking for a reason to convict Kyle, if you're of that mindset, if you're of that persuasion, then he's giving you the silver tongue approach, right? He's silver tongue. He's giving you all the things that you need in a well-constructed persuasive speech. This is me at my best when I'm doing persuasive speeches. I've won competitions doing persuasive speeches, and I'm like, well, yeah, he has kind of the same same hallmarks. He could win some competitions too. So he was an effective public speaker. But then, of course, Nick Ricciata's chat turns on me, because if I say anything positive about the prosecution, they start saying I'm not a very good lawyer. I never want to have you as a lawyer. You're an evil asshole. Why are you this evil? I never want to have you. You're out of your mind. You're insane. And I'm like, just trying to evaluate one thing at a time over here. This is so far as it goes. Now let's talk about the back half. So in the first half, it was like 9 out of 10 or 10 out of 10. Same as his opening speech was throughout. So his opening speech was pretty much a home run. Of course, there were some problems. There were some minor issues. In his opening, there were some organization issues. I wouldn't maybe have put things in the same organizational structure. There was some signposting issues where things weren't quite spelled out in terms of where things were. But overall, it was pretty much flawless. 9 out of 10, 10 out of 10. Award-winning speech in the opening. In his closing, the first half was like that. In the back half, after the break, not so much. It was more like 4 out of 10. It was muddied. It was jumbled. It was at times incoherent. It's maybe lost as to where we are or where we were going. I couldn't follow the point half the time. Couldn't follow things where things are going or where they're coming from. I found it very hard to construct and anticipate where he's coming from. And so it's like I can't follow the story. I can't see where this is developing. It was just jumbled and it was bad. And also he made some very interesting tactical fails, the most notable of which was when he asked the jury himself to put themselves in Kyle's shoes. Now that is beyond bizarre for a prosecutor to do. A prosecutor doesn't do that. A prosecutor asks you to put yourself in the victim's shoes, which incidentally they can't do because there's case law on it, but they'll try to do it other ways, right? So they can't directly say put yourself in the victim's shoes because that's there's case law on that. But they can try to do it more sharp. They can try to do it more subtly, or they'll try to put you into, a situation that would be more comparable. But then what they'll never do is say, put yourself in the defendant's shoes. And what would you do? Because all of us are looking at this and be like, right? This will also be in the rebuttal, and I'll get to the rebuttal more later. But where the rebuttal guy was saying, basically and he says, no reasonable person would have behaved and Kyle did. And I and the entire rest of the panel on Nick's channel, like all 10 of us, are kind of looking at each other like, well, we thought we were reasonable people. And we're like, yeah, that seems like a reasonable course of action to me and the rest of my panel. So, not so sure about that one over here. I've definitely seen a lot of unreasonable people, including people who claim self-defense. It definitely has happened. This is not one of those times. But before I get to the rebuttal period, let's talk more about Binger's second half. Yeah, there was this confusing element of put yourself in the Kyle shoes and how would you have felt. And there were some other tactical errors where he just made some points that seemed more appropriate for the defense. Nothing that was, except for that one line, which I thought was particularly notable. Joe had counted, I think he said 12. I think while I don't disagree with Joe as to the elements, I just think that a good half of them are more kind of inconsequential. I mean, Joe's trying to find every flaw he can, which, you know, fair enough. That's a reasonable approach, right? To find every flaw you can and be like, well, this is a flaw. I'm like, yeah, maybe it is on some sort of like level, but if you weren't hyper paying attention, you'd never notice. Even I missed half of them. You know, when I was paying attention, maybe he was looking harder for those flaws, so he's really trying to scout them out, but it didn't pop in my head as it was happening. So, what do I mean by there being case law against asking the jury to put themselves in the victim's shoes? Exactly that. You can't do that. You can't ask to put the jury in the victim's shoes. Hold on. Let's see. Yeah. This is a Fifth Circuit. I'm trying to find the exact cases. Yeah. Golden rule argument. Yeah, it's called a golden rule argument. You're not allowed to do that. Yeah, personal attacks are independent on the counsel. You're not really allowed to do, which incidentally the defense was pushing that boundaries. Commenting defendants exercise constitutional rights. We heard that for sure. Inflaming passion or prejudice of the jury. Sending a message. You're not allowed to say that. Fear of vengeance or community protection. No. The golden rules. Yeah. So, an example, State versus Lowry. 427 P 3rd 865 Kansas. Maine Supreme Court, State versus Tarbo. Wisconsin Supreme Court. So there's lots of decisions along those lines. You can't ask to put yourself in the jury's shoes. That's a no-go. Anyways, or apologize, put yourself in the victim's shoes. That's a no-go. I got distracted. All right, so anyways, where was I? Yeah, so it was muddled. So now let's go to Richards. Richards, for my taste, I think opened a little less strong than Binger. Now, Joe disagrees, and I think his point may be right. He might be right. It's not like a huge difference. It's a bit stylistic. I think Binger is just better at being a silver tongue. I think Richards came out strong, and he came out bold, and it was effective, but it just doesn't quite resonate quite for me the same way that Binger does. I'm not saying it's bad. It just doesn't. It's not quite doing it for me. So maybe this is more of a personal taste kind of thing. But then again, I'm the one giving the evaluation, so you know, fair enough, right? So you might evaluate differently. So if you want to say that that Richards had the better opening or the better start of his better start, then okay. I just don't personally think it. What I think Binger did, what I think Richards did do is he was much more consistent for longer. So I think that while he may have started at say 7 out of 10 as opposed to 9 out of 10 or 10 out of 10. Well, Richards probably was starting at like 8 out of 10. So maybe for me, it's Binger was 9 or 10 out of 10 and then went to like 4. And Richards starts at like 8. And then his tail in sort of decreasing was not as sharp. So he wound up maybe with a 7 out of 10 overall. So he wound up with a much more consistent, smooth, style in terms of his overall speech, where you didn't have this jarring effect that you had from Binger. So it was more consistent for longer, and I think overall was the better closing for it. I think whatever magic Binger had at the opening, I think when he came back he kind of lost it, and then when Richards really came and started so strong, because Binger had finished around 4 out of 10, right? That's why I just said Binger finished at like 4 out of 10. So when Richards is starting at like 8 out of 10, right, by juxtaposition, it sounds so much stronger. So while it might be weaker than Binger's opening, it's so much stronger than the end of it that the juxtaposition makes it seem like really jarring. And I think that is exactly what the jury experienced, or at least to me and him. So I found Richards, well, first of all, Richards showed up to the party. So there's that. I mean, to say I had no confidence in Richards, I mean, Jesus Lord, I don't think anyone's going to contest that proposition. I have been critical of Richards throughout, pretty much at every stage. There have been times when I've said some nice things about him, but mostly not. Most of the nice things I've said about the defense have been Sharifi. And when Richards got up there and started to give his closing, I thought, okay, we're all going to die. And this is going to be horrible. It's going to be like his opening where I literally was falling asleep. I couldn't, it was so bad. For me, it was bad. I mean, it's like 3 out of 10, 2 out of 10 when we're going back to his opening statements at the start of trial. Again, me, right? It was doing nothing for me. There's no story. There's no narrative. There's no vocal variety. There's no nothing. And whatever good points were in there were so buried in a complete cluster of confusion that I was like, I don't know what the hell's going on. At least I was able to follow Binger at least a little, even at his worst. So even at his worst, I don't think Binger was as bad as Richards was in the opening. Personal opinion, but that's what I think. But Richards finally shows up to the party in the closing. Where was this guy the whole time? He kind of sucks at direct. He kind of sucks at cross. He kind of sucks at opening. And then, Lord have mercy, somehow he picks it all together during the closing. Where was this guy? He had a very no-nonsense, factual-based approach. It was very unemotional to the point where he forgot to ask the jury to put themselves in Kyle's shoes, which, man. But, it was very factual. It was very good. He started good. He started strong. I really liked what he did by going through the witnesses one by one. I like that he put the witnesses' photograph up there because no one is going to remember who these people are by name. There's no way on this God's green earth. But by putting the photograph on them, you get the mental connection, right? It's like, this person testified. Like, who the hell is that? Even if it's Dr. Black, who the fuck is Dr. Black? The jury's probably thinking to themselves by this point. So by putting the pictures of these people, it's like, oh, okay, I remember that guy. I remember him. And it's like suddenly, I'm remembering his testimony in my head. Really, really nice, really good. And going through it chronologically is a great way to organize your remarks. He goes through it. He lays it out. He brings up all the good points. He highlights everything. He brings out what was bad for the prosecution, right? He doesn't really make any mistakes along the way that I noted. So really, really nice. So during all that stuff where he was laying out things chronologically, it was very good. And then he got into the back half of his speech where now he's going through like the pictures and the videos evidence, which was less good because during the first half of his speech where he had the witnesses and the photographs, he had something to guide him. He had the witnesses, right? So he could have folded the stuff. He could have done one of two things. Like he could have either folded the back half of his stuff into the first half, and so he could have folded into the witnesses where appropriate, or he could have redone the witnesses with specific respect to the evidence that he's bringing on at that point. But I found the back half of his speech a little disconnected. It didn't really have a great arc to it. Now, it wasn't bad though. It just wasn't great. It was factual. It was informative. He was making lots of great points. He was bringing lots of good things to the jury's attention. I didn't really dislike anything he was really doing, except that there was so much of it. I think this is to his detriment. There's a great saying that adversity from art, or art, yeah. Art breeds adversity, or no, adversity breeds art, the other way around. Adversity breeds art, or art from adversity. It's one of those things, art from adversity. And the idea is if you have restraints, your art is better. And one of the classic examples of this, in honor of Binger, one of the classic examples of this is the original Star Wars, Episode 4. Episode 4 had a shit budget. It had no money. And most people think Episode 4 is really, really good. And then when George Lucas suddenly got all the money and he's like, oh, now I get to go back and do what I really want to do the whole time. Let me add in all the special effects ever. Now Episode 4 suddenly sucks, right? So Episode 4 was better when George Lucas didn't have any money. the art came from the adversity. He was able to make a better product. And then when he had all the money ever, he managed to fuck it up, as we also saw from the Star Wars prequels and other movies. So sometimes when you're constrained, you get a really good result. And I think this was a bit of a problem, both for Binger and Richards, to be quite honest. They both would have been better off shortening their speeches. They took advantage of all the time they had on the table, and I think that was a mistake. The using 2.5 hours, it's just not possible. Well, I won't say that. It is possible, but it just takes a lot of work to really give a 2.5 hour persuasive speech. That's really hard. You know, and State of the Unions aren't that long, and they're not that long for a reason. It's hard to keep people focused no matter how good what you're saying is, no matter how good your speechwriters are. So I think Richards would have been better off at 45 minutes or an hour and a half. I think he somewhat undermined himself by using basically all the time he had available. Again, I can't point you to any specific thing that he did wrong. He was bringing in a lot of great evidence. He was bringing in a lot of great testimony. He was bringing in a lot of good photos. He was illustrating everything well. But I think he could have done the same thing in effect with less time. I think he used the amount of time he had available. It's another one of those things is, I don't know if there's an official law for it, but the law of meetings, where if you have a meeting at work, the meeting will take as long as the time is scheduled to take, right? So it's like, how long should the meeting be? Yeah, you and your coworkers want to have a meeting at work. How long should the meeting be? Well, the meeting will consume the time that you allocate for it, right? So this is probably known to everyone except management, who somehow can't get this through their skull. But if you allocate 2 hours for the meeting, it will take 2 hours. If you allocate an hour for the meeting, it will allocate an hour. If you allocate 5 minutes for the meeting, it will take 5 minutes. And it's not necessarily worse for being 5 minutes as opposed to 2 hours, as anyone who sat through any torturous meetings at work, I'm sure, can testify to, right? We said everything we need to say long ago. Now we're just draining it out in a lot of pain. This is what it reminded me of. It reminded me of a manager who's like, oh, let's have 2.5 hours for a meeting, when it really could have been done in an hour, if not less. And I think it was to Richard's detriment to use all the time. But that being said, although I think he did lose the jury a little bit along the way, if at any point they were paying attention, everything he was saying was good. So I think, he might have lost them a little bit in the back half, because who can pay attention that long? Unless you're listening to one of my live streams, because my live streams go much longer. My live streams are always awesome, even if they last for 3 or 4 hours. They're always great for all of them. You love my live streams, no matter how long they are. But if you're not me, if you're Richards or Binger, then, you might want to constrain yourself a little bit more, because, yeah. So overall, it was great. It was nice to see, a lawyer actually show up for Kyle. That was nice for a change. That was really pleasant. I enjoyed that. So now let's talk about, what's his name? Kraut, who with his rebuttal closing, and holy God. Man, that was just painful. I don't even know how to rate it. It was, I guess 2 out of 10 as an angry screed. Oh, I forgot one thing, and I can't believe I forgot it. I have to go back to Binger. I'm sorry, I forgot. Binger pointed an AR-15 at the jury. All right. This is just great. This has got to be big. I don't know how the jury perceived it, but I'm willing to bet there's a few firearms owners and be like, some people maybe not that comfortable with firearms. Binger took an AR, he put it up at shoulder level like you would to shoot, and he pointed it at the jury with his finger on the trigger. Now, let's go over the basic rules of firearm safety, because Binger has apparently never heard these basic rules of firearms before. But that's okay. I'm an NRA basic pistol instructor. And although I'm a basic pistol instructor, not a basic rifle instructor, I'm quite confident the basic rules of firearm safety are the same. So let's go over the basic firearms rules of safety, shall we? Rule number 1, the firearm is always loaded. Rule number 2, don't point the firearm at anything you don't intend to destroy. Rule number 3, keep your finger off the trigger until you're ready to fire. Yeah. So, he just saw it cleared in front of him, but, the basic rules of firearm safety, it's like, unless you yourself just cleared it just now, it's a live weapon, right? I can literally see the RSO or the trained whatever clear the firearm. I can watch him do it. But if I know anything about firearms at all, I'm going to clear the firearm myself. Because basic rules of firearm safety. I might have literally just seen you do it just now. I'm going to do it again. And then when I hand you the rifle back, guess what you're going to do? You're going to do it again, having just seen me do it. Even though there's like no ammo anywhere in between. Because that's how paranoid we are in the basic firearm rules of safety. Binger over here apparently has not gotten that memo, which also was evidence from his stance with this whole chicken wing thing. I don't know who fires a rifle like this with this huge ass chicken wings. And also, I'm not really sure how persuasive it is when you're pointing a rifle at the jury. There's a couple people there that are probably not that comfortable with firearms. A couple people there who probably think firearms should be banned. I mean, the jury is supposed to be a representative cross-section of the community, right? So if it's a representative cross-section of the community, one can reasonably infer that among 18 people might be some people who have maybe some negative opinions about firearms, to start with. Maybe this might make them not comfortable. Super duper fun. Super duper fun. So yeah, people were like, so Richard, I unfortunately, I think technically, and this is, I can't believe I'm about to say these words, but this is, I think, the law. I think you can't charge Binger because he has absolute immunity for anything he does as part of his prosecutorial function. And it's hard to imagine something that's much more core of the prosecutorial function than literally giving a closing argument. That's pretty core of the prosecutorial function. So up to and including if he had somehow fired the rifle and it had a bullet in it and struck a juror, I don't think you could charge Binger because absolute immunity. But that's a different discussion for a different time, man. We're not going to get too hung up on the parameters of absolute immunity. So unfortunately, I think charging Binger is right out. But yeah, it was not a great moment. It was not a great moment. It was his goal to make them uncomfortable. Well, if that was his goal, man, mission fucking accomplished. All right. Could he be disbarred for that? I'm not 100% sure that violates any of the rules of ethics, to be quite honest. I'd have to go through them again. I guess we could go to competence. We can always go to competence, but I'm not sure, man. Yeah, the rules of ethics for an attorney were not designed to deal with the don't point a firearm at a jury, though. The rules of ethics were not written in contemplation of that. Absolute immunity does apply to criminal, Matt. Yes, it does. Yes, it does. Unlike its brother, qualified immunity, which, as we know, does not apply in the criminal context. Absolute immunity does apply in the criminal context, Matt. Yes. That is one of the major distinctions between absolute and qualified. Qualified, no qualified immunity in criminal cases, but absolute immunity, criminal cases, no day long, man. All those good things. All right, so now that I've talked about Binger and his shit poor gun handling skills, let's go back to Krause with his let me get mad and yell at the jury rebuttal. I don't know about you. I try to be fair. I try to be as fair as I can, and Lord knows I get crap for trying to be fair. I even said on Nick Rakita's stream when I was trying to evaluate Binger before the close, I was like, well, let me see if I can piss off the entire chat right now, right? Because I know what I'm about to say is going to piss off the entire chat before I say Binger did a good. And then on Twitter, I made this comment about, yeah, now I'm trying to now apparently I'm playing the game. Let's speed run how fast I can lose Nick's channel. their chat. How fast can I lose Nick's chat? Apparently, I'm speed running that game. So I try to be fair, and I try to be honest in my evaluations, no matter who it helps and who it hurts, because that seems like a good thing to do. So I might be biased, but that rebuttal from Krause was horrible. It did absolutely nothing for me. It just seemed like him angry and yelling at the jury, and it's got to leave a bad taste in their mouth, I would think. I can't imagine anything in there was particularly persuasive. It didn't feel persuasive to me. It felt angry and like you're a bunch of idiots and all the rest down. All those good stuff. So all those good times. So yeah, I didn't really do anything for me. 2 out of 10 shit show of just let's insult the jury and berate them and all the rest of it. It's just and then also where did he say? He said about the beatings. What was the exact quote he said about the beatings? Because I tweeted it out. Yeah, what was the exact quote about the beatings? Let me see where he said that was a good line. Hold on. What was the line? Everyone takes a beating sometimes. Wow. Yeah. Everyone takes a beating sometimes, says Krause. It's like, man, if you have one domestic violence victim in there, or someone who knows a domestic violence victim, right? I mean, you got 18 members of the jury. What's the probability one of them is a domestic violence victim? What's the probability one of their sisters or their wife's friends is a domestic violence victim? And you just said everyone takes a beating sometimes. Wow, that was an epic moment. That was great. Wow. They were just trying to hit him, and everyone takes a beating sometimes. Oof. USNEA helps dry me up. Ooh, let me try that. I'm always looking for new nasal solutions because I have allergy problems, as we all know. Okay, so that is my evaluation of today. So it was a and then of course there was the big win of the day, which somehow I also neglected to mention. So the big win of the day was the tossing of the minor in possession charge, which Nick Rikita properly argued was crap. And I agreed with Nick's analysis. I was softer about it because I don't really know why I was softer about it. I probably should have had a stronger opinion, but I didn't. I don't know. I just maybe there's something I'm missing, I guess. But even though I read the statute a couple times, I'm like, I don't think I am. But for whatever reason, I was like, maybe there's something I'm missing on this. But yeah, the minor in possession charge is completely legally insustainable. For him to be in violation the way the statute was written, then he'd have to be in possession of a short barrel rifle, which no, because you'd have to have a tax stamp and all the rest of it. So it's not a short barrel rifle. And even the prosecution said, we're not contesting it's a short barrel rifle. And then the judge just said, okay, dismissed. So it's like, but they wanted that to go to the jury. They wanted that to go to the jury. They know they don't have it. They know the rifle is not short enough. They're like, we're not contesting that, and you better believe they measured or had someone measure. So they know they don't have it. They know they don't have it, and they're like, well, we still want to go to the jury because maybe we can bamboozle them. And that is the kind of thing that puts everyone in a little bit of sense of despair, particularly the lawyers. Well, not particularly the lawyers, but we get hit on it on a different level because of the blight on our profession. But watching this prosecutor, I'm going to take this to the jury because maybe with a little razzle-dazzle, they'll draw the wrong conclusions. And willing to take that when he knows he doesn't have it. It's saddening. And it's really, it makes me feel I mean, that more than anything made me feel like this guy is not an honest actor. And I know a lot of you guys reached that conclusion for other reasons. Perhaps it's because I always want to see the best in my profession. Maybe it's because, like, even if I sharply disagree with you, it's like I'm a little bit reluctant, maybe. Maybe it's a courtesy among sharks thing. I don't know. But I'm a little bit reluctant to throw another attorney under the bus unless it's sort of the last conclusion. So, but watching that today, I was like, yeah, you know, I have to throw you under the bus because you're a bad lawyer. You as the prosecutor in particular, have duties, special duties. You have special rules of ethics just for you. You have special rules of ethics just for you. They only apply to prosecutors. There's a whole section about it for you. And they are like things about doing justice and not bringing frivolous charges and, you know, not bringing charges that are not sustainable and the rest of it. And they knew they didn't have it. They knew they didn't have it because, of course, they didn't. And right up until the last minute, they were able to bamboozle the judge. Fortunately, the judge caught on and threw out the charge as he should have. But, you know, it's one of those moments that brings a little bit of despair to your heart because it's like, you know, you don't like to see tarnishment in your profession. You don't like to see tarnishment in your profession. And when you're seeing that and you're like, you know, you don't have it, you're bringing along something you know to be bogus and you don't have it and you're continuing to press it because you want to go to the jury. It was not great. It was not great for my esteem of my own profession. So fun times. So, yeah. I'm getting more recommendations from the chat on allergies. It's prescription? Okay, well, maybe. So the whole thing is just really weird. So the jury is left with 2 murder charges, 1 attempted murder, and 2 reckless endangerments. I was surprised the prosecutor didn't make a bigger deal out of provocation. They certainly made a deal out of it, but I was surprised it was not even a bigger thematic element for them. I did like what the defense did about trying to undermine the provocation. Like, you never heard about this from them before, and trying to undermine this, like they changed the theory, trying to trick you. That was really nice from the defense when the defense finally decided to show up. Excuse me. But yeah, so we got the 2 murder charges, the attempted murders, and the 2 reckless endangerments. And we only got the provocation instruction once, and we got self-defense instructions multiple times. I think the prosecution did a good job at raising by asking yourself to be in Kyle's shoes. I wish the defense had played that emotional note a little bit more, but they gave them all the facts about it, and they certainly did a good job showing the chaos and the rest of it and all the things that relate to that. So. Good deal. So now the question is, okay, so what's the jury going to do? And then it's like, okay, well, first of all, I'll give you my odds. My odds have flipped again since yesterday when I was blackpilling everyone again. My blackpilling, I think, yesterday was well justified because it was well justified based on the fact that I thought that Richards was going to be asleep at the switch. So, you know, I thought that, you know, using the past to make predictions about the future would be a reasonable thing to do. But Richards decided to show up, and he did really good. And also, the prosecution kind of imploded in the back half of theirs, and even more importantly on rebuttal, which, you know, you wouldn't have anticipated because their opening was particularly good, so you wouldn't have expected them to implode. So we got some unexpected things that changed the calculus, which is why we revised the calculus as needed on an ongoing basis. So yesterday, I said like 70% to convict or for a mistrial, which I think yesterday was roughly correct. I think today, though, you're looking at maybe the other way around. Now you're looking again about 70, maybe higher actually, 80%, maybe even higher still, 85? It's up there, whatever it is. You're looking at a very high percentage for an acquittal versus a mistrial. There's still the provocation instruction in there, which can mislead the jury. But the defense did a good job making the photograph completely ridiculous. Razzle dazzle, or whatever the phrase was, hocus pocus and out of focus. That was the one. Hocus pocus and out of focus. That was a nice little Johnny Cocker moment there that was enjoyable. So, yeah. So I think you're looking at, let's say 90. Let's say 90%. I think you're looking at 90% for a acquittal or a mistrial. I think you still have chances of conviction, because here's the problem. Again, these are I'm basing this on, at least in part, on Barnes's numbers. Barnes said when he did the jury consultant thing, he found that Kenosha was one of the best counties for Kyle. It was one of the most favorable counties for Kyle. Even though it was one of the most favorable, he said that 2/3 of jurors start off with a negative impression of Kyle, and 1/3 of jurors are like diehards. They will never be convinced. So a lot goes to jury selection, right? What is the probability that 1/3 of the jury is one of those diehards that will never be convinced and hasn't been convinced? So that's part of the calculation I have to base in the back of my head and trying to calculate out these numbers or these probabilities. So I'll take that as a given. 1/3 of the population of Kenosha is a diehard. That's what Robert Barnes says. I have no reason to doubt him. So if they weren't very careful on jury selection, then you have the possibility that someone won't want to give up. And so you have the possibility of a compromise verdict because there are lesser includeds, right? Even though, as a matter of law, if they reach self-defense on the top count, they're not supposed to look at the lesser includeds because it doesn't make any sense. Depending on how long these jury deliberations go on, you could see the possibility of 1 or 2 real diehard standouts driving the jury to some sort of compromise verdict. And the lowest compromise verdict they can give at this point, I believe, is the reckless endangerment, which still carries a 12-year sentence. So even the lower stuff that's left on the table at this point carries some serious jail time. So that's one of the reasons I'm not higher. I'm not higher because I'm basing it off of what Barnes tells me about the underlying demographics and the concern that maybe they're not that great at jury selection. So I think that 90% is, or 85% is about as high as we can realistically be because of that underlying information. If I didn't have that underlying information, I'd be more confident. But because I have that underlying information, I have to hedge my bets a little bit more. So all those things. So we'll see. Now, of course, it's possible for the jury to come back hung on some verdicts and not hung on other verdicts. So they could come back guilty on some verdicts, not guilty on other verdicts, hung on other verdicts, right? So there's lots of different combinations. Every charge is unto itself. So, whether or not they'll come back with partial verdicts, who can say? Reckless endangerment's a max of 12 years. It's a max of 12 years and 6 months. So, you wouldn't necessarily expect Kyle to get all that, especially since he has no criminal history. But, that's still. I don't think time served is a possibility because I don't know what the minimums are, but I don't think time served is going to happen. So, yeah, I think 85 or 90% is as confident as we can be for acquittal across the board or a mistrial. I still think there's a fairly decent residual chance. There's some diehards out there who will say, but he brought a gun and he was looking for trouble despite the evidence to the contrary. And the first half of the prosecution's closing gave them a reason to hold on to that if they're looking for it. So I think that's the most honest assessment you can give. Is juries are always a crapshoot to some degree because you don't know what they're going to focus on. They could get bogged down in the jury instructions. I mean, they are 36 pages long, right? Or 34 pages long or whatever they are at this point. They could get bogged down in the jury instructions. They could focus on one piece of evidence more than another. They could do some weird things. Juries do some weird things sometimes. They could focus on one piece of testimony that, all of us have forgotten about, but for some reason becomes their favorite thing. Juries can do. Are there lesser includes for reckless endangerment? I don't believe so. I don't think there's any reckless includes or lesser includes there. So I think yeah, the odds are about 85-90 for an acquittal or mistrial. Now, of course, in the event of either a mistrial or a guilty verdict, the judge can say, how about not guilty? So a judgment as a matter of law So if the jury doesn't come back with a verdict, then it would still be a judgment as a matter of law, right? So the jury says we have no verdict. So then it's a judgment as a matter of law. The judge says, okay, how about not guilty? If the jury does come back with guilty, then there's a verdict. So then it's a JNOV, right? So different labels for the same thing. But either way, the judge can insert a not guilty verdict if he's so inclined. I wouldn't put high probabilities on it. I'd put a higher probability here than your typical case. I think that the evidence is shit, and there's certain indications from the judge that seem to think that he thinks it's shit. But, of course, there's political fallout problems, and he's already received death threats and the rest of it, and he's desperate for very legitimate reasons. He's desperate for very legitimate reasons for this verdict to be accepted by the community. And he doesn't want to overly interfere in the process. And also, of course, JNOVs and JMOLs are just rare, period. So they're very, very rare unless they just fail to meet an element, which is when you get a dismissal on the charge. So, I would not bank on the probability of the judge entering a not guilty in the event of mistrial or guilt, but it is possible. And I think more likely from this judge than not. Or not, let me rephrase that. That was way too optimistic. It's more likely from this judge than your typical judge. I think Kyle got about the best possible judge he could, which it seems, at least as to that much, Law Twitter appears to agree with me, because Law Twitter appears to think that the judge is an alt-right fascist Nazi who is secretly simping for the white nationals or something. Okay, all right. It's weird. It's really weird. So all that stuff. To the almost 1,000 of you who are currently watching, thank you, by the way. If you want to ask a question, you only need to ask it once. And what you do is you just precede your comment with either the word question or @Uncivil Law, and the bot will capture it. And I'll try to answer as many for as long as I have energy. And thank you to all the people who've been super chatting along the way. Let's go Binger indeed. Let me see if I can find the other people, the other super chats, because they didn't save for me, and I would like to acknowledge them. So give me a second. Let me see if I can find the other super chats that came in tonight, so I can acknowledge them, because I would like to do that without, give them the respect, because they donated to me, and I'd like to give them the respect of reading their stuff. It's it's something that I can do to show them my appreciation. Now I know it's in here somewhere. Now I just have to find it. Okay, here we go. $10 from JT Brown. Thanks for the insight. Fellow South Carolinian and Clemson Tiger. Go Clemson. I found you from the breakdown of SLED Barney Fife raid up in Myrtle Beach, where they shot that guy 28 times and lived. Lol. Thank you, JT Brown. That was a fun stream. And of course, he won in the end. He got a nice settlement from the Myrtle Beach because, his rights were very, very violated. Overheads 18 said $5. I said, I have jury duty starting tomorrow. I will not react well if an attorney points a gun at me. Thank you for coverage of this in the Scottish gun case. You are welcome. $5 from SK Wisegar. Barnes thinks the gun pointing was a trap he's trying to get Richards to fall into, so he could say even he thinks it's provoking. Well, maybe. That's an interesting idea from Barnes. He was doing it deliberately, so Richards would say objection and say even he thinks it's provoking. I don't know, ma'am. I don't know. Maybe. I don't know if that's giving Binger too much credit or not, but it's a hell of a gamble, because Richards is not exactly known for his objections. Right? Richards is not exactly known for his objections. So Barnes thinking that Binger was doing it deliberately because Richards is going to object. I mean, would you think Richards is going to object if you're Binger? Yeah. Joshua Sanders says $5. Okay, there's no way he has absolute immunity. You couldn't bring in a stripper down and start banging her and then be like, see, that's how he did it. I bet you could. Donald Engelman said $2. Low poll, just intimidate with a gun to win. And then there's a question about whether or not he could be disbarred for that from Ricardo, and I don't think so. Jay Petty says, Binger's a good public speaker as long as he's not under pressure or angry. Fair. The nonalists gave $5 and said, I'm still pissed that Binger pointed a gun at the jury. First rule is never point a gun at anything you not want to destroy. The first rule. Well, for me, the first rule is the gun is always loaded, but different instructors teach them in different orders, so. Jacob Papa of 6, congratulations on that. You're beating Nick by 1. The judge has not ruled or heard on the motion for mistrial with prejudice, correct? That's correct. They've not ruled on it, so I don't know what's happening there. Torrance Davenport gave me $5 to say, if politicians spoke like that, I'd actually listen to them. Love the context. That was actually for last night's stream, but you get a credit for it anyway because I didn't notice until I was done reading the super chat. So thank you to all the people who donated super chats. And now I will read some of your non-super chats until I get tired or whatever. So let me figure out where I left you guys. Great, there you there. Kay becomes a new supporter. Thank you, Kay, for becoming a supporter. All right, so let's answer some questions from the bot. If I can find where Discord is. I'll get back to you, Matt. Someone said they're watching me on YouTube. Great commentary. That was very nice. Thank you. All right, so let's... Oh, there's even more stuff. All right, I'm going to deal with that later. Too much stuff happening. Let's take a look at the bot. What does the bot have for me today? Matt Dennison says, do you think the judge has been giving the prosecution rope to hang themselves and tends to set aside the verdict that the jury might stumble into? He isn't buying a lot of BS. I wouldn't bank on it, man. It's a unlikely thing, even in the best of circumstances, and this is high profile. I would not bank on that happening. Matt says, can you talk about justifications for less lethal force, like pepper spray? Can it be used before an incident escalates to the standard of imminent death? Yes, you can use non-lethal force, or less lethal force, I suppose. Well, you have to be careful with that because some less lethal force might technically qualify as deadly force. So, like, for example, shooting a beanbag out of a shotgun might qualify as deadly force for the purposes of a statute. So it's not like, I don't want you to get the impression of, oh, I can just do this for all less lethal force. It depends on your state. But let's just say that you can use, well, we'll call it non-lethal force. You can use non-lethal force in the response to a non-lethal threat. So if someone punches you, you can punch them back. You can't shoot them just merely for punching you. The situation here, of course, was a little bit more than that, particularly with the death threat. So that would make one of the differentiations, by the way, for the use of deadly force here. But yeah, you can use non-deadly force to resist non-deadly force or to protect property. In many circumstances, that's okay. Although even then, for property, you have to use it in the least way, and it has to be reasonable. So don't go crazy on that. Shane says, are you a trial lawyer? And if so, how many trials? I'm not a trial lawyer. My work is on the transactional side of patent law. I do have a couple trials, but most of my experience from public speaking comes from Toastmasters and other public speaking courses because I really enjoy public speaking. Rogue Jen says, don't worry if chat, and also from reading a lot on trials from people who do it. So I've read a lot of books on the subject. Rogue Jen says, don't worry if chat agrees with you. Tell us what you need to hear, not what we want to hear. That's what I try to do. Cody says, I think without the great cold opening on day one, the prosecution did well enough today to win them over. Without the great opening? I feel like the defense was really flat when they needed a good day. Really? Cody thinks that the defense was flat today. I don't agree. I mean, they're certainly flat in their delivery. They're unemotional and a little bit monotone, so the public speaking stuff could still use some work. But I don't think they were flat today. I thought they had a very good day today. Melanie said, prosecution says something to the effect, we've all taken a good beating now and then. Yeah. Cthulhu is alone says, as a balding redhead, I believe everything you say. Well, Thanks for stroking my ego, Cthulhu is alone. That's real grateful. Melanie said, so prosecutor said use a deadly weapon, not that one. Kind of. They also said you should fire shots into the air, which is recklessness. But, you know, never mind. Reginald Knox says, do you think Kyle will be found guilty in the first degree of reckless harmless? I gave my odds. I think it's possible, particularly as a compromise verdict. I don't think it legally makes any sense, incidentally. Matthew says, your live streams follow the same rules of meetings. You just don't set end time, so they end when time runs out. True. Is it significant that Binger didn't do the rebuttal? No, not in particular. And it was a good move, particularly because Binger had been attacked, but his co-counsel wasn't able to be that dispassionate, so it didn't really help. But I don't think there's anything significant about it. It allows that guy to just pay more attention. I think it's a good idea, all things considered. Michael said, well, Binger clearly wanted to destroy his chances with the jury, so maybe pointing at them was intentional to that cause. Alex Baldwin would have been better off following the rules. That's true, Matt. Melanie says, he argued that Kyle was in the wrong for having the weapon at low ready. Then he goes on and fully aims at the jury. True that, my friend. Hell Pike says, wouldn't that make him guilty of provocation? Well, now the jury can legally beat him. Yes, actually it would make him guilty of provocation because as the prosecution themselves noted, it doesn't matter whether the gun is unloaded or not. Right? So even though the gun is unloaded, yes, he legally provoked them. So one of them could have gone up and beaten his ass. That would have been hilarious. But I think we're better off this way. Connor said, research on Nexus the elements of a civil suit for malicious prosecution. Can Kyle overcome there must have been a probable cause for the institution of formal proceedings? Probably not. Maybe on the weapons charge, but probably not. Anonymous says, ignore the echo chamber people. Honestly, they're not worth your time. But I want to be loved by everybody, Anonymous. I want to be loved by everybody. Michael says, do you think Richard should have thrown more objects towards Cross's rebuttal? Because he threw himself off balance and got angry. Oh, no. Oh, no. Should Richards have thrown objections towards Krause when he's angry? Hell no. Let him seem like an angry, belligerent ass to the jury. That seems like the right thing to do to me. Pull up your pants, take off the bra, and be a man. I don't know if that's exact quote. I don't remember the bra part, but I do remember the other parts of it, like be a man and toughen up. Someone recommended USNEA for my allergies. Michael said, oh, they've just been beaten up in school by a group of bullies that chased that jury member. True that. After closing today, Richard's new name is Turn Up Richards. He might actually win a case. Duck Pone says, Binger seems like the type of guy who'll go to a party, clog up the toilet, and not bother to find a plunger or even tell anyone. He'd play dumb and let someone else take the heat. Tessa says, can someone on the jury call jury nullification on something like that? As the law books say, they have the power but not the right. But I don't think they have to do jury nullification because I think he's not guilty by the law anyway, so I don't think we need nullification on any of this, the way I've seen it. Anonymous says, maybe you can get an allergy test done. I've gotten the allergy test done. It didn't help that much. Zeno the Stoic said, go spend months in the barn. If you survive, it'll fix it. Everyone takes a beating now and then. Peach said, Binger pointed a gun at the jury. Do tell. I kind of did tell, but yeah, he pointed the AR-15 right at the jury, man. He shouldered that AR right up, and with his wings fully out, because he's obviously never held a rifle before, and with his finger on the trigger, he pointed it right at the jury. Great moment in prosecution right there, let me tell you what. Let me tell you what. I'm going to have to like make a shorter clip out of that and post it to my channel at some point because it's just too much. Where was I? I've lost my place. Outdoorsman Show says no one's going to talk about Mr. Binger's basic firearm safety during the entire argument, where he took an AR-15, had his finger on the trigger, and held the guns toward the jury. Oh, yeah. Brian Prognosis is hung jury. Most will kit, but there'll be some holdout leftists. Could be. Could I read all the offenses charges? Well, all the offense charged are 2 counts of murder, 1 count of attempted murder, and 2 counts of reckless. If you actually want me to read the jury charges, it's 34 pages long, and I'd have to explain it. Because, you know, that's the kind of guy I am. Because I'm a lawyer, and I'd want to explain it. So if I actually read the jury instructions, all 34 pages of them, we'd be here for a little while. Maybe if I get bored to tomorrow and the jury hasn't come back, maybe I'll do it then. But not tonight. Anonymous says, how long do you think a jury might take? If they take a long time, is it good or bad? It usually is the consensus that in the majority of situations, a short time is good for the defense. The idea being that a jury can't convict in a short amount of time because they'll want to really go through the evidence and stuff like that. So it's generally thought that if it's shorter, it's better for the defense, particularly when you have these charges and they're so complicated, right? In terms of things. So if they just come to an easy self-defense thing and they just yeet the whole thing. So shorter is better. But if they come back in an hour and somehow it's guilty, you know, it's not a guarantee. Do I think Kyle's behavior during the trial helped dispel the negative impression? Yeah, probably. Are the less included for reckless? No. Could the judge seal their info so the mob will never come after them, particularly for the jury, and maybe increase their chances of fully acquitting Kyle? I don't know the law when it comes to juries and their identities being sealed or not. I don't know what the law is as it relates to that in Wisconsin, so I can't comment about that. JS said, didn't the defense waive JNOV because they didn't move for a directed verdict? No, I don't think so. I don't think so, but I don't know for sure. You might be right, but I don't know for sure. I don't think so because I don't think so because a JNOV, judgment notwithstanding the verdict, it can be said if it's against the manifest weight of the evidence as well. So there can be technically enough. Yeah, it's not an issue of whether there's technically enough to convict or not, or it can be, but it's not necessarily limited to that. So you can have a technical sufficiency of the evidence, but the judge would say it's against the manifest weight of the evidence. So yes, while there's a technical sufficiency of the charges, the overwhelming weight of the evidence is against. And so you would send it to the jury because there's a jury question there for the jury to decide the fact, but it's just that in the end it doesn't matter. So I don't think it does, but I don't quote me on it for sure. How many times can the case be retried? It always ends in a hung trial. Infinitely, as many as I'm aware. If any conviction is reached, will Kyle still be out on bond for appeal? It depends on the judge, but almost certainly not. Should Richard, yeah. Keep up the good work, says Jay Good Games. Thank you. When's the Lawyer D&D stream? When I find enough people to play with me, man. Kenneth says, where's the hat? Don't always wear the hat. The hat is special, much like home. You haven't earned the hat yet. Michelle says, is it ethical when the prosecutor will straight up lie about the facts in closing? Again, you have to be very, very careful here about when you're calling something a lie. I'm not saying the prosecutor didn't lie. Maybe they did, but a good lawyer doesn't have to lie. Not that they're allowed to anyway. But you're allowed to make insinuations that imply the lie. Right? So you're allowed to say things that, while technically true, or at least technically viable, right? You're allowed to say things that, while technically viable, you're allowed to say them in such a way as to imply a lie. So I don't know if he flat out said any lies. He might have. I mean, the rebuttal prosecutor, when he said that there's no such things as left-handed rifles, I mean, that's just wrong. I don't know if he's lying. I bet he's not. because he sure as hell doesn't know what the hell he's talking about. So, strictly speaking, Krause didn't lie when he said there's no such thing as a left-handed firearm, because in order for it to be a lie, you have to knowingly do it, and he doesn't know because he's an idiot. So that's just not true, rather than a lie. So did Binger ever lie? I'm not saying he didn't. I didn't catch anything to me. But, you know, we could go through the transcripts with a fine-tooth comb and see whether or not he lied. He was pushing the envelope at some points, that's for sure, but I think he was there. Ignorance of the law is no excuse. In fact, it is an excuse. Fiery Red Podcast. Yeah, ignorance of a lie is an excuse, yeah. In order for something to be a lie, it has to be knowingly wrong. If you're just wrong, it's not a lie. Lies, I mean, at least this is true in federal law, and it's true in every jurisdiction which I'm aware of, right? In order for something to be a lie, it has to be knowingly wrong. If you're just wrong, it's a mistake. If you're just wrong, it's being an idiot. In order for something to be a lie, you have to know the truth and tell the lie. So yeah, ignorance of the truth is in fact a defense to a lie. It's also a defense to a perjury charge. So, you know, it's not perjury if you didn't lie, and it's not a lie if you didn't know. So yeah, it's a defense. Sure is. Someone said, no, Uncivil, you have to be careful about what you call a lie. We're lawyers. We have no obligations to be fair. We're not lawyers. We have no obligations to be fair. Okay, I guess that's true. Producing manipulated images. Well, they're manipulated, and everyone acknowledges that they're manipulated, right? He said they said they were enhanced enough. He didn't lie about that. He didn't pretend that they weren't manipulated. He said they were manipulated, so they're not a lie. You know, yeah, okay. Is a lie if you believe it at the time? If you believe it, no. If you believe it, it's not a lie. I think Jerry Seinfeld said as much once to what's his name in the show. Jason Alexander. I forget it's George. So yeah, Jason. Freddie or Jerry Seinfeld said the same thing to George. Remember, it's not a lie if you believe it. And that's true. It's not a lie if you believe it. That's right. What is best in life, says Cave Cranman? To crush your enemies, to see them driven before you, and hear the lamentations of the women. Cave Cranman, that's what's best in life. Jonah says, did the prosecutor pointing a weapon at the jury have any intimidation? I think so. Why do you think the second half of Binger's closing fell flat? I don't know. It just really fell apart. What are you drinking if Kyle gets off free? Whatever is convenient. Whatever's convenient. Oh, Lord. Incognito says, could you give all 4 attorneys a final grade on performance? It's a little bit hard to give secondary counsel grades because they were a little bit off to be seen, but Binger overall gets the better grade, I think, in terms of his advocacy, in terms of his being a human being. He's a douche. But I'd say that, and he comes off as smarmy when it's unnecessary. So I'd say overall, Binger comes off, I'd say maybe a B+. God, Richards was so bad for so much of the trial. It's like, what do you give the student who basically sucks ass but pulls it together in the final exam? Do we give him a C-? Is that too mean? Mike Bob Gaming says, in the event of a not guilty verdict, how quickly do you think the prosecutors are going to file for an appeal? I don't think they're going to file for an appeal in the case of a not guilty verdict, because they can't appeal a not guilty verdict. So how fast do I think the prosecutors will appeal the not guilty verdict? Never. Steven says, how common is it for jury to go along with something? Yeah, compromise verdicts are known. What audiobook should Richards narrate? Oof. If it's a hung jury, can both parties appeal? There's nothing to appeal in the case of a hung jury. It's just a do-over. What's a good Western-style hat for a broke law student? Asking for a friend? I don't know, my friend. You have to go to stores and find out what you like. You have to when it comes to buying a hat, it's personal. You have to find something that speaks to you. Brian Bremer says, searching Binger on Google suggests Binger points gun at jury as top suggestion. Jack says, is a late verdict good or bad? Would it be better for God to have a morning? The general wisdom is it's better for the defense if it comes in soon. But that's not a universal rule. Not necessarily true. If it comes in late, it's not bad. It's just, you know, the idea is if it comes in really fast, because there's so much to discuss. If it's really fast, it's because they found a short circuit, like the self-defense, and it was able for them to resolve it really easily. So the idea is if it comes in really fast, it's not guilty. Can the judge still rule mistrial with prejudice? I honest to God don't know, River Girl. Joe Helen says, do you see the defense got competent help today during Binger's prosecution? Kyle was helping out the defense. I saw him talking. I don't know about what. Does Rittenhouse still face the possibility of civil lawsuits? Yes. How does this trial affect potential civil litigation? Well, if Rittenhouse is found guilty, he will for sure as hell be found liable in civil litigation. If not, then, you know, the people can sue him for wrongful death, but, you know, good luck with that plan. Outdoorsman Show says, can I join you on stream and talk about firearm issues? Not today, but, you know, send me a DM on Twitter or something and we'll look into it for a future time. Jared Dolan says, why didn't the judge sequester the jury? Sequestering isn't free in terms of the impact on the jury. I wasn't talking about cost issues because the cost doesn't matter. It's so inconsequential. But there's impact on the jury. The reason you don't sequestering comes at a cost to the jury. It can be fatiguing. It can be, you know, it can really be disruptive. It's really disruptive to the jury, really disruptive to their lives. It can be fatiguing. It comes with its own set of collateral consequences. So sequestering the jury is usually thought of as a, at least by most judges, it's very disfavored because it puts so much burden on the people. It is a bit of an administrative hassle, and it can cause the jury to rush to judgment when they shouldn't. Liberty Death says, after I graduate law school, how likely would it be for me to serve jury duty? Depends on your jurisdiction, Liberty. I've only been called up to jury once, and the entire panel got dismissed before the case because it settled at the last minute. So it's never happened to me. Jen says, from a Wisconsin lefty who acknowledges the evidence to convict is not there, what is with referring to Kyle's hero? I don't really remember referring to Kyle's hero, although I'm not saying it didn't happen. I definitely remember the prosecution referring to the mob as heroes. But I might have missed it, but I couldn't really speak to that issue. I don't remember that. Kay says, did you see the defense shaking as he sipped his water at the beginning of their closing? I did not. And I wouldn't read too much into it. My hands shake all the time. CR, do defense and prosecutors ever talk about the case and not agree to object too much? Sure, it can happen. $5 says, why aren't you with Good Logic and Runkin? I didn't know they were streaming. And besides, I've been doing this on my own channel pretty much every day too. And it can only be in one place at a time, man. No disrespect to Good Logic and Runkin, but, you know, I've done my own analysis at the end of the day for every day where I can. So, you know, I'm gonna do that. Richard says, if he's guilty, is Kyle going to custody right then, or is he out till sentencing day? Again, it's up to the judge. He could technically extend the bond, but you would expect him to go into custody immediately. Jay says, was that a new hat you were wearing earlier? No, it's not a new hat. I've worn it before. It's in a lot of my videos. I've had it for about a year. It was custom made for me by Texas Hatters, and I love it very much. Do you think Kyle or anyone else would have eaten a favorite meal and done other things like it could be his last night free? Couldn't speak to that, Richard. Michael says, no, I meant throwing off generalized objections to piss off Cross. I don't know. I think he was pissed off enough, and I think it wouldn't necessarily work. Prosecution thinks the Glock is less lethal than an AR. Give me a handgun over AR at 4 feet. I mean, fair. Do you think defense will appeal guilty verdict? Yes. There's several grounds to appeal. I'm not sure how good any of them are, but there are multiple grounds to appeal. Not for the least of which is ineffective assistance of counsel, although that's very difficult. Drew says, if you go back to the charging documents, do you think the prosecution presented any evidence for all of it? The charging documents, I think, made the defense's case for it. It was the most bizarre charging documents I ever saw in my life. Nick has said, and I tend to echo it, that if you didn't know better, you think the defense wrote it. Eric says, what happens if there's a hung jury? We get a do-over. Question says, if you had to be stuck in a whole room with Binger or Cross, who would you pick? Binger for sure. He might be smarmy, but I could learn things about trial advocacy from Binger. If there's a hung jury, what do you think the odds of our retrial? I think they're very high. If Kyle's found guilty, is he sentenced as a juvenile? No. George says it's not a lie if you believe it's true. I thought that was Jerry, but okay, I'll take your word for it. Does perjury require a lie? Yes. Yeah, so you have to know that you're telling a falsehood. It does require a lie to commit perjury. Can MSM be sued by Kyle? I don't see it. I don't see it. Will the drop weapons charge me for Dominic Black? They don't mean anything for Dominic Black. I don't think Dominic Black's guilty of anything either, but they don't imply anything that I'm aware of. Is not knowing the law an excuse? Not typically, but not knowing can be part of the law because the law itself often requires knowing as a mens rea. So Mike says, is not knowing the law an excuse? Well, no. Not knowing the law is an excuse, but a knowing state of mind is often in the law, right? So you can have intentional, knowing, reckless, or negligence. Those are your typical four. And sometimes you have other things, but those are your typical four. Intentional, knowing, reckless, or negligence. So it's not that you don't know the law, it's that the law itself requires a knowing state of mind. And if you don't have it, then you're not guilty under the law, whether you knew the law or not. So you can know the law and not still have a knowing state of mind. Like for example, I know the law says that if I have a knowing state of mind and I tell a falsehood, it's a lie. So I know the law, but if I don't know it's a falsehood, I'm still not guilty. So it's not ignorance of the law. It's that the law itself says I'm not guilty because I didn't know. Someone asked about what happens if the jury reaches a verdict and judge rules on dismissal request in the affirmative. I don't know, man. Is there any circumstances where not guilty is appealable? I think a JNOV is technically appealable, but it won't go anywhere because the judge enjoys wide discretion. If the judge read the law on murder to say no killing was illegal was appealable, would be in Canada. Not if the case has already gone forward. Right, so if it's appealed before it goes to the judge, right? So if it's dismissed preliminarily before the case goes forward, you could appeal and say, no, that's the wrong reading of the law. We want to have the charge. But once the case started, no. If the judge says, well, you know, murder's not illegal, so I'm going to dismiss. Double jeopardy, man. I'm surprised nobody jumped at the DA saying steel jacket rounds instead of full metal jacket of copper. You know, for me, Psycho Boy, I have to say this. I understand the difference as a firearm shooter. I get it. But I don't really think in this context it really matters that much. I don't really think the jury is going to super appreciate any sort of difference between a steel jacketed round and a copper jacketed round. Do you really think to the average person, even the average firearm owner for that matter, that they really have an appreciable difference of steel jacket versus brass jacket? It's metal. It's close enough. So I didn't think that was a point worthy of making. It's a distinction without a difference in this context, in my opinion. The Buick Skylark or the Pontiac Tempest, nice reference back to My Cousin Vinny. I missed 2 super chats, so I tried to answer them all. $5 from Irish says, appreciate what you guys have been doing the whole trial. Whereabouts do you practice? I do patent law. So my practice is national because patent law is a federal practice, but I practice out of Texas. Kyle says, people, don't be so hard on Richards. He's a local with local mannerisms and dialects, which is comfortable and relatable. Tactics, y'all tactics. No, I don't agree. If this is all part of some Midwestern food that has somehow completely escaped my attention, I don't know what to tell you. So maybe there's some Wisconsin defense lawyers out there who think that this is really, really good. So if there's some Wisconsin defense lawyers out there and they want to have a YouTube panel about how actually the rest of us YouTube commentariat are full of shit, and actually this was really good from Richards, then, you know, I'd love to see it. But no, I'm not seeing it at all. Any chance of plea bargain? Sure, there's always a chance of plea bargain prior to sentence, prior to it being entered. But I don't think there's a plea being entered. The odds at this point, I think, are about 85-90% for innocent or hung trial. Yeah, I got around to it. Kyle G, I'm sorry, I just missed it. How long can they hold the dismissal? I don't know. Someone said, have you ever flipped through so many pages you've accidentally licked your thumb to swipe on your phone? I can't say it's never happened, but, you know. And, okay, so that's the end of the chat. That's the end of the chat for tonight. So I appreciate the 980 of you who are currently watching. I'm not really intending to be on the stream with Nick for tomorrow. Maybe I'll pop in. But I'm actually going to go back to work, you know, to my day job. I was off the last 2 weeks. I was off the last 2 weeks planned. And then today I just took a personal day as well because I wanted to be there to the end. So I'm actually going to have to go back to work. But can you explain why the gun charge is dismissed? I don't get it. Well, the reason why the gun charge was dismissed is under the relevant statute. Under the relevant statute, there's a couple different exemptions if you're under 18. So one of them is hunting, and then another one deals with possession of a rifle that's so much length and whatever. So the technical reason why is because the rifle wasn't below the length for a short barrel rifle. But I mean, I could get into an exact breakdown, but that's why. Unum Pluribus says, I did some manual patent searches for my local library back in the 90s. It's interesting what was the most common stuff. Fair enough. Yeah, I could get into the exact breakdown, but it's because of the exact wording of the statute. Thank you for your insight in the panel. I appreciate you played devil's advocate. I know it fell flat on some. You know, right? Jeez, of course. All right, so I'm going to sign off for now. If you've enjoyed this stream, please remember to give it a like. For the 935 of you who are currently here, have you considered subscribing? And if you have considered subscribing, are you sure you're still subscribed? Because, I don't know, maybe Susan unsubscribed you. Maybe now's a good opportunity to double check whether or not you are subscribed. So that you know won't be confused if, you know, Susan hates you. Incidentally, if you're not getting notifications of my videos, you can follow me on Twitter, because that's really the only thing I've ever used Twitter for up until like the last couple days. Because why not just have a little fun with it? But I make all my, there's an automated bot to make all the announcements on Twitter of my videos. So there's another way to find out about my videos, in case you're not getting the notifications. And did you know for a mere 99 cents a month, you too can become an uncivilian? It's true. You will see some members of the chat that have these wonderful, cool little icons by their name, like Blackbird and A. Hedinger and Cody Sams, these little scales in various colors. Sometimes red, sometimes blue, sometimes other colors. You might think to yourself, these scale icons are really, really cool. I wish I had a scale icon by my name. Well, fret not, my friends. You can have a scale icon by your name. If you hit the join button for a mere 99 cents a month, you too can become an uncivilian and help support the channel financially and help us grow. It helps a lot. It helps a lot. It helped me with getting a new PC so my render times aren't shit. And it helps me with getting other things to get this together. So I really appreciate it. So I'd appreciate you doing all those things. Thank you, Aluminum Tech, on 18 months. That's really, really great. So just do all the YouTubey things. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.